Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hello and welcome to Hull on Estates. This is episode number 705. I'm Stuart Clark.
And I'm Aaron Chan.
Hello, Aaron. Good to be podcasting with you today.
Yeah, it's been a while. Nice seeing you again, Stuart.
No, I think we got an interesting one here today. And it's a topic, it's in part a topic that we've been talking about a lot and blogging about a lot in the last couple of weeks and months. But from a different perspective, because a new case has come out, which makes you kind of, not rethink it, but, go, hey, isn't this funny? And so the basic, the last couple of months, we've been talking a lot about the Ingram and Kolinich estate decision of the Court of Appeal, which is 2024 ONCA 678. We have blogged about it. I've blogged about it a lot. We've podcasted about it a lot. So we're not going to do another deep dive into that. But it's interesting because that decision came out in September of 2024, September 12th to be exact, 2024. Then a few weeks later, on October 28th, 2024, we have the Court of Appeal again released another decision, this one called Gomes and Silva, 2024 ONCA 792. And the two files talked about similar issues, but they each kind of exist in their own silo, and they don't talk about each other, and they use different analysis to come to conclusions which are similar, I suppose, but different. So I thought it'd be kind of neat to talk about it today. But before we get to Gomes, very, very brief summary and review of the Ingram and Kolinich estate decision. And the big issue there was the question about limitation periods in equitable claims against an estate, where the equitable claim is seeking an interest in real property. So going back years and years and years, as far, at least in my own memory, there's been a debate about whether or not when you're bringing an equitable claim post-death against a deceased person, saying I through equity should have an interest in real property forming part of your estate, do you have the 10-year limitation period under the Real Properties Limitations Act to bring that claim, or do you have the more harsh 2 years from death under the Trustee Act to bring that claim? And the implications there are potentially huge, right? I mean, if an estate trustee has to wait potentially 10 years if the estate has real property before making, distributions for fear that someone could come along 9.5 years after the fact to bring a claim, that's a huge burden. Whereas 2 years, it's a bit, quicker, we'll call it, right? It's 2 years, it's still something, but it's not 10 years. And the Trustee Act has a relatively harsh, application if it doesn't care about discoverability, right? The Trustee Act says you got 2 years from death. I don't care when you discovered your claim, bring your claim, do it now. So we now have a clock running 2 years from date of death. Well, in Ingram, as anyone who's listened to the podcasts or blogs, I read the blogs knows, decided that it was the shorter 2-year Trustee Act limitation period that applied. So you have 2 years from death to bring your equitable claims, regardless of whether or not it has real property in the estate. You don't have to wait the 10 years. So now you have if you're an estate trustee, the reprieve is that you don't necessarily have to wait 10 years to make distributions out of fear. If you run out the clock on the 2 years, you're probably safe, subject to a few exceptions that we've talked about, like situations where you have minors or incapables, and you can read our blogs and all that about that. Great. Everyone was, not everyone, but we were happy about this. We have an answer. We can now give advice to clients. Estate trustees, you got 2 years. Don't worry about it. You're good to go. Trustee Act is your friend. Court of Appeal and Ingram and Kolinich told us so. Thumbs up. Aren't we happy? Well, that was September, as I said, 2024. October 2024, only a few weeks later, Court of Appeal releases the Gomes and Silva situation. Similar fact pattern. It's a kid bringing an equitable claim for constructive trust against his mom's estate for an interest in property that was owned by mom. And one of the issues, lo and behold, swirling around this was limitation periods. Was the kid within the limitation period to bring the claim? Now, interestingly, the words Trustee Act are never mentioned in the Gomes decision, not once. The only analysis that the Court of Appeal does, or any court does, is on the 10-year Real Property Limitations Act. So you go, gee, well, that's kind of odd. Didn't we just have a long court decision where it told us that the Trustee Act was the one we had to care about? This was only released weeks apart. Now we have the Court of Appeal doing a big analysis on the Real Property Limitations Act in a scenario where someone has died and they're bringing an equitable claim against the estate. Isn't that funny? We'll get there eventually. But maybe now, Aaron, can you give us might be a good time to give a basic kind of summary of the fact pattern here in the Gomes decision?
Sure. So just briefly, in the Silva, there were four siblings who were unable to agree on the ownership and disposition of the family home. And that family home had formerly been in the name of the deceased mom. At the time the home was purchased, the deceased mom and father had held an undivided 50% interest as joint tenants, and the appellant held the other 50% interest. Following the father's death, title to the home was then held by the mother, 50%, and the appellant, 50%, as tenants in common. And finally, just prior to the mom's death, she transferred her interest to all four of the siblings. So at the end, the appellant held title to the home in 62.5% interest, and the respondent siblings each held 12.5% interest in the home. And at trial, the court granted the respondent siblings' claim for petition and sale of the property and rejected the appellant's claim for resulting trust. And on appeal, the appellant contended that there were four issues, but for the purposes of this podcast, since we're focusing on Cullen's estate, the third issue that the Court of Appeal addressed was whether or not the trial judge erred in finding that the resulting trust claim was statute barred by Section 4 of the Real Property Limitations Act. And so, as Stuart already pointed out, on appeal, none of the parties was arguing that Section 38 of the Trustee Act provided the relevant limitation period. So the appellate court wasn't being asked to address this limitation period problem. The court straightforwardly applied Section 4 of the RPLA. The appellant had knowledge based on a letter that had been sent to him from his deceased mom in 2008 that his deceased mom would not be honoring any resulting trust over the home. Any claim should have been brought by the appellant by 2018 at the latest.
Yeah, no, thank you, Aaron. So, I mean, yeah. So what happened here, right? I guess is the first question. I mean, we don't know this for sure, but if I'm, my guess is that the Trustee Act probably wasn't thought about or brought before the court, either at the lower level or at the Court of Appeal, just because of the fact pattern that we had here and just, the only analysis that the parties had done on the Real Property Limitations Act. And again, don't know this for sure, but it looks like these two cases were decided by different judges at the Court of Appeal who were probably in their own, silos and didn't talk to each other and didn't know that they had very similar fact pattern cases before them. So, in the instance of Ingram and Kulinich, we have, 2-year Trustee Act, you're out of time, go away. And then in Gomes and De Silva, we have more than 10-year Real Property Limitation Act, you're out of time, go away. Same outcome, different statutes. So does it matter, right? Now, my own, thank God moment is that Gomes was statute barred, right? I'm imagining a scenario where the kid was at 9 years instead of 10 years, and the analysis was, oh, good news, you still got a year to go and your claim's good. Because then you have a scenario where the Court of Appeal, a month after Ingram, is saying, well, you got 10 years still to bring these kind of claims against an estate. And then there's that flip Ingram on its head. That didn't happen here. They're both out of time. So my, analysis, our own thought process in going through this is I'm not sure it changes much, if anything, in Ingram. I mean, Ingram is still a good law. The Trustee Act analysis is still good law. Gomes arguably would have been hopefully out of time under the Ingram analysis too, but the court didn't even have to get there because they were more than 10 years out and the Real Property Limitation Act applied and kicked them out anyway. That's how I'm going to read it. I'm curious to see, obviously, how this goes in the future, because it is so interesting that we have the Court of Appeal. So same, appellate level court, considering two very similar cases or kind of claims so close together on limitation periods, and one using one statute that's a shorter statute and one using the other statute, which is a longer statute. Same outcome, as I'm saying, you're out of time on both. So I don't think it impacts the Ingram analysis, but it's certainly interesting, right? It makes you think, go, wait a second, well, why did we spend all this time on the Real Property Limitations Act if only a month before you told me not to worry about it?
Yeah, it's a good point, Stuart. And when I was reading both cases, and I guess this might be a bit of an arbitrary distinction to draw here, but I think maybe like this court in De Silva, they may have been guided by the language of the RPLA specifically. So just to quote Section 4 of the RPLA, It states here that no person shall make an entry or distress or bring an action to recover any land or rent, but within 10 years next after the time at which the right to make such entry or distress or to bring such action first accrue to some person through whom the person making or bringing it claims. And it keeps going on. So I think that we're focused on that part that says, or bring an action to recover any land. So if you look at De Silva, the appellant was claiming an interest in real property. He wasn't claiming an interest in all of the estate assets, which I think would have elevated his claim to something like what you find in Cullinich. It would have expanded his claim far beyond just his deceased mother's real property. It was just a claim to recover his interest in the home, and he wasn't asking the appellate court here to consider the estate assets. But if you look at Cullinich estate, the respondent there was making an equitable relief claim for, quote, an order that the respondent is entitled to an interest in the estate by virtue of constructive trust or resulting trust in relation to all estate assets. So I think that's why, again, I recognize this may be totally arbitrary, but I think that's why in De Silva, the court may have just found that this was a straightforward case to apply the RPLA. But in Cullinich estate, there was a bit of this issue with applying different limitation periods.
No, I mean, maybe you're right? And as I said, like the good news here,
again, I could totally be wrong.
He was more than 10 years out anyway, so the result is hopefully the same, regardless of which Trustee Act or Real Property Limitations Act you're applying. I mean, these lines of kind of the thought process of equitable claims and interests in land and tenure in the estates context have been kind of pulled historically frequently from family law, right? Because you often see these kind of joint family venture claims being put forward on the breakdown of relationship. There's always a question of, well, if as part of that joint family venture, you're seeking an interest in real property that was owned either collectively or by one or whatever it is, do you have 10 years to bring that kind of claim, or do you have like a shorter limitation period? And on the family law side, I mean, my understanding is it's pretty definitively answered, well, you got 10 years, right? The court has said that's Real Property Limitations Act. You're seeking an interest in real property, even if it's an equitable interest. And therefore, you got 10 years to bring those kind of equitable claims against someone while they're still alive. And that's a big important asterisk here is, you know, they're still alive in this instance. But what happens if in the context of that kind of claim, even if it's a joint family venture kind of claim, one of them passes away, right? So, you know, before the claim is brought, the person dies. Or if it's a, you know, instance like Gomes and De Silva, it's a claim against your mother's estate, right? And they passed away. You still have that 10-year period to make the equitable claim, or do you have a shorter 2-year from date of death Trustee Act? And Ingram would suggest that you got 2 years, right? So even if under normal circumstances you're in a breakdown of relationship, joint family venture, you got 10 years to bring your equitable claim for real property. Well, if spouse B dies, you know, within that 10-year period, you don't, and say it dies, you know, 3 years into that 10-year period, well, you don't get to run out the clock the rest of the 10 years. You got 2 years now from that death under the Trustee Act to bring the claim, is how I would interpret Ingram. And I think the same would hopefully apply to Gomes. As I said, it just so happens that the issue wasn't brought up here. I mean, thankfully, the conclusion was limitation period anyway. So I don't think we have to throw out Ingram or, you know, seek further analysis of, you know, which one's the correct one. I think they can both exist in their own silos and don't contradict each other. But it's an interesting question, right? I mean, my gut is counsel didn't bring it up or think about it or, you know, run through it, which, you know, I don't have any reason to know that's for sure the case. But the fact that the words Trustee Act are never once mentioned in the decision makes me think that's probably what happened, is the counsel just said, well, you're 10 years out, go away, you're out of time. And the court said, yeah, you are. Could they have gotten there under the Trustee Act as well? Maybe. I don't know. I don't know the exact fact pattern here, but probably. But, you know, thankfully, at least in my own interpretation, I'm going to hang my hat on it for now. I think these two cases can exist together and not contradict each other. And I think Ingram and Cullinich, even though we're September, so now we're in early November, but we're barely at it was 2 months, you know, 2 months right now that the decision came out. And the fact that we're already having to wonder, wait a second, is it no longer any good? I mean, I think it's still good. I hope it's still good. I'm going to say it's still good until someone tells me otherwise. But it's interesting, right? It's because we got these two decisions on very, very similar equitable fact patterns coming out so close to each other and coming to, I mean, the same conclusions using different statutes. Makes you kind of go, huh, well, that was weird. But it's interesting, right? I mean, if nothing else, it forces you to work through the analysis that we've gone through today, which is, what is a claim in real property, right? And is an equitable claim a claim in real property? Give you 10 years, or give you 2 years, and in the classic lawyer answer, it's probably, well, it depends. But if you have a dead person involved, my initial reaction would be, well, you're probably on a 2-year clock, and see Ingram.
No, honestly, Stuart, I think you're right. I think the simple answer is just it wasn't an issue that was brought up by counsel before the Court of Appeal, and the Court of Appeal just decided not to rule on that issue.
Yeah, no, I mean, in fairness, right? I mean, these are very, very, very busy judges. I can't imagine they're wandering around the halls, chatting to their friends, being like, "Hey, tell me every decision that you're thinking about right now to make sure that they don't, have similar fact patterns, that we're not going to say different things." I don't know what happens behind the scenes. Maybe that does happen, but my gut is that we just have a classic scenario of different judges at the Court of Appeal hearing similar cases in a similar time period, coincidentally, and using a different set of analysis to come to what I think is hopefully a non-contradictory similar conclusion. But it's interesting, right? Because you do have this scenario where you have similar equitable claims but different statutes. But yeah, no. Interesting decision. It was Gomes into Silva, 2024 ONCA 792. For anyone who's interested, I'm sure you'll probably hear more about Ingram and Kolinich, just because I know it's been a hot topic recently, at least with our own office, and I think at many other offices and blogs and CPD events and all that kind of stuff as well. So I'm sure we'll hear more about it, and it's just interesting to have another case from the Court of Appeal so soon after, where we can kind of think, it makes you work through the thought process again, at least, and kind of think, well, what are we dealing with here? And I think they're not contradictory. I think they can both exist in their own world, but only time will tell. Maybe I'm wrong, and maybe Gomes was the court rejecting Ingram, but 2 months after it coming out. But I don't think that's the case. But yeah,
I agree completely, Stuart.
Oh, interesting chat today. So we'll make sure those cases are posted along with the link to our podcast today. Until next time, it's been great podcasting with you today, Aaron. And I'm Stuart Clark.
And I'm Aaron Chen.
And see you all next time. Thank you.
Thanks.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.